Justice Kavanaugh?
Back to the question on clear authorization regarding damages in particular. You rely heavily on Tanzen for that, but even after Tanzen, to pick up on Justice Gorsuch's point about the courts of appeals have continued to reject the position you're articulating here, even in the wake of Tanzen. Chief Judge Sutton's opinion in Ali is probably emblematic of that and says, even after Tanzen, you still don't have the clear, express, unequivocal, unambiguous authorization for damages. And so my question really is just why are judges, to Justice Gorsuch's question, misreading the precedents that are out there, in your view?
Yeah, I'm glad you asked that. Maybe 2 points where I think Judge Oldham has the better of this, with all due respect to Judge Sutton. And honestly, is the first thing that I said. Judge Sutton, if you look at his opinion in Ali and also his prior opinion in Haight versus Thompson, he does not ask the question of whether there's an individual capacity action. He goes right into the sort of appropriate relief analysis. And I think that is just a critical step, because once you see that there's an individual capacity action, then you have an express right, an express cause of action, expressly against a private party. And then whether damages are appropriate relief, I mean, that's the norm. That's what individual capacity actions are for. If you don't have it, the individual capacity adds nothing. It's totally meaningless. And I think it's because Judge Sutton sort of overlooked that first step in the analysis that I think Judge Oldham has the better of it. I also think that when you're asking, once you're actually turning to the question of, okay, we have the individual capacity action, we're trying to figure out what is appropriate relief, another thing that Judge Oldham hit really hard, which is very powerful, is the whole point of this law, which everybody knows, is to go back to the pre-Smith scheme and provide the same rights and remedies that were available, including in the original RFRA, which this court said, made clear, must include damages against state officials. And so I think that the parallel, I mean, these are hardly even separate statutes, right? Like RFRA and RLUIPA, they work together as an integrated whole. And so to understand them, I think that really the only way to understand their operation together is as providing the same rights and remedies within their scope. I mean, RLUIPA, Congress was crystal clear in RLUIPA about the places where it needed to trim its sails because this was spending legislation. It's on the face of the statute. It's not RFRA 2. It's the Religious Land Use and Institutionalized Persons Act. It only applies to institutions that accept federal funds. That's on the face of the statute. It's clear as day. But if you look in at the substantive provisions and the remedies, and you look, well, how have those changed because this is spending legislation? The answer is not at all. The rights and the remedies are the same. The whole point of this statute is to get back to the pre-Smith scheme.
The whole